All right, good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I'll let you know if I've determined probable cause based on the police reports I've read this morning, and also we will talk about release conditions. Please note that today is not your trial date, and so I encourage you not to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at a later time. If you are represented by the attorneys from the Public Defender's Office, they are available for you to speak with. I do have Mr. Brian Reed in the courtroom with me, and over at the main jail, you have an attorney from the Public Defender's Office there with you as well. At the other facilities, you are able to speak with them by phone. I'll also let you know that I have in the courtroom with me attorneys from the State Attorney's Office, as well as I have representatives from confinement status, pretrial supervision, and the clerk of courts. If you're represented by private counsel and the attorney's not here, you can let me know, and we will see how we can accommodate you through that process. But please don't tell us that you're represented by private counsel and have us make a phone call only to find out that they're not representing you on this case. Unless you or your family hired private counsel for this arrest, they may not be representing you on this just because they have represented you in the past. So you just need to know that, all right? There are a few persons that the jail has asked us to call out of turn. So we'll start with Daniel Davern.
He's here, President. Judge is approaching. Come on up, sir.
All right, Mr. Davern. Mr. Davern is before the court. Charge 1 is aggravated assault with a deadly weapon. It's domestic. Number 2 is touch or strike battery, also domestic. Number 3, tampering in misdemeanor proceedings. The court does I find probable causes to these charges. And does anyone wish to be heard as to bond?
Your Honor. Just one moment. Let's see what's going on here. Your Honor, I see no criminal history. That being said, I am very concerned regarding this case, specifically Mr. Davern. First, I would note the level of violence and the physical condition of the alleged victim. I would also note that in January of this year, the city of Coral Springs petitioned for and obtained a risk protection order against Mr. Davern. And there was a final order for risk protection issued February 12th of this year. I'm going to be seeking a $20,000 bond on count 1, $5,000 bond on 2, $1,500 on 3, no victim contact, pretrial release with a GPS monitor.
Okay.
Judge, in speaking of Mr. DeVerne, as you heard, he has no prior criminal record. He is a registered voter in our community. He basically has very strong ties to this community. He's been here for over 18 years. He's 22 years old. He's gone to school here. He was raised here. Unfortunately, at this time, he's not working. He's basically financially supported by his family. And I don't think his family is going to assist him as far as with the monetary amount with the bond. Having said that, Judge, when he was arrested, he unfortunately didn't have his phone with him, so he has no way of contacting anyone, friends or anyone, to post a monetary bond. So he's in a tough situation right now. Judge, we have no objection as far as if the court wants to place him on supervision with level 2 with the monitor. He's pretty confident that he has friends that will allow him to reside with him, but he just doesn't have their contact phone numbers. So, Judge, at this time, we're asking you to take that into account in determining reasonable release conditions for Mr. DeVerne.
All right, the court does have concern.
Judge, I would just like to add one thing. I
Yes.
did speak with Mr. DeVern's mother
Okay,
before court. She was at James's bond agent, actually James, called me and put me on the phone with her.
Okay,
I think she has some concerns about Mr. DeVerne. And she indicated to me that there could be a history here.
right, well, with the obtaining of the risk protection order, that says something. Also, the alleged victim in the case is his mother, who is disabled. And so, all those things have to be taken into consideration. So at this time, I am going to impose a $10,000 bond on count one, a $5,000 bond on two, 1,500 on three, and, no victim contact. And if Mr. DeVerne's bond is posted, he will be on level two pretrial. Okay? I'm sorry? That's, yes. Okay, Robert McGee?
One moment, Judge. Mr. McGee is approaching. Come on up, sir. Be careful.
All right, Mr. McGee, Mr. McGee is before the court for robbery with a firearm, and the court does find probable cause.
Your Honor, the state would be seeking no bond hold upon a finding of proof evident and presumption great, relying upon the allegations in the probable cause affidavit, also noting Mr. McGee confessed post Miranda, not only to this robbery, but another armed robbery at a 7-Eleven. I acknowledge that he claims he used a BB gun. He could still be convicted of robbery with a firearm or deadly weapon. I would note on count one, which he was also charged with robbery firearm, he's being held on a $50,000 bond.
Okay,
Judge, we would object to the court setting a no bond hold at this stage of the proceeding. The state has not called any witnesses or introduced any physical evidence. Proof evident presumption grade is the highest standard of proof we have in the criminal justice system, and having introduced nothing other than a probable cause affidavit, we would ask that the court set bond for Mr. McGee and not make a finding of proof evident presumption great. However, if the court is inclined to make that finding, then we would ask the court to exercise its discretion and set a monetary bond for Mr. McGee.
all right, at this time, the court finding probable cause, I am going to make that preliminary finding of proof evident presumption great based on the affidavit, and that has been presented to me. Mr. McGee will be held no bond, and this is without prejudice for him to have a bond hearing before his division judge, okay? Cody Pope,
Cody Pope is approaching, Judge.
all right, Mr. Pope, you're before the court this morning. Counts one and two is selling methamphetamines, and number three is trafficking in amphetamine, 20 grams less than 200 grams, and the court does find probable cause.
Judge, in speaking with Mr. Pope, as the standard bond's $105,000 is something Mr. Pope does not have. He's 27 years old. He's not employed. He's basically supported by his boyfriend. They live locally here in Fort Lauderdale. They've been residing at the same premises for about a year and a half. From what he advises me, he has no property to his name. He has no money in the bank. Judge, there's really not much financial resources. I'm asking specifically on count three, the $100,000 bond, which is currently set. I'm asking if the court would consider reducing that from $100,000 to $25,000.
Your Honor, Lynette De Los Santos on behalf of the state. At this time, the state would be requesting that the $2,500 bond on count one and $2,500 bond on count two stay in place, as well as the $100,000 bond on count three. The charge of trafficking of amphetamines has a 7-year minimum mandatory. The defendant also has a warrant out of the state of Georgia. It's a 2017 violation of probation of an aggravated assault. There's also a 2015 possession of methamphetamine from Georgia. And the defendant also has a Tampa address, so there is a flight risk.
Okay,
And there are prior failures to appear.
okay, thank you. Okay, all right, finding probable cause, at this time, I am going to leave the standard bonds in place on all 3 counts, okay? Nestor Nunez,
He's approaching, Judge.
all right, Mr. Nunez is before the court for aggravated battery with a deadly weapon. I find probable cause. Does anyone wish to be heard as to bond?
Your Honor, one moment. He's been the state prisoner.
Yes, Your Honor. The state at this time will be requesting a $10,000 bond on count one, no victim contact, GPS pretrial monitoring. In this case, Your Honor, the defendant has a 2003 prior battery.
Judge, I'm going to be requesting a $3,000 bond on Mr. Nunez's behalf. My understanding is he gave me the phone number of his employers, and I'm going to be contacting them, and he's hoping that they will be able to assist in posting his monetary bond. Now, he's been working at the same place for about a year now. He works at Goodyear as a mechanic. He lives in Hallandale locally with his wife. Where they rent, they do not own, and their rent is approximately $1,100 per month. As you heard, his prior contact with the system is quite dated, back in 2003. Mr. Nunez did talk to me. I did inform him today is not his trial date, but he really much wants his day in court to dispute these allegations. He was basically defending himself from what Mr. Nunez advised me. Judge, we're going to be requesting, like I said, a $3,000 bond on Mr. Nunez's behalf.
All right, the allegations that I have before me is that the alleged victim tried to ignore Mr. Nunez when he walked in the moment he walked in the store. He was questioned by Mr. Nunez. He tried to ignore him after he made his purchase, walked out of the store. Mr. Nunez followed behind him and started a fight. So based on those allegations, looks like we may have conflict in the story. I am going to impose a $7,500 bond, no victim contact. All right, on page 24, we have Craig
Judge,
Wilk.
can I have a photo order? I
Sure.
forgot to request that.
Sure. Craig Wilk on page 24. Good morning, Mr. Marantos.
Good morning, Your Honor. Ross Weiner on behalf of the state.
Good morning, Mr. Weiner.
Judge, Mr. Wilk has private counsel.
He does, he's right here.
Oh, there you go.
All right, so Mr. Wilk, you are before the court today. Charge 1 is possession of cannabis 20 grams or less. 2, 3, and 4 are DUI with damage to property of person of another. 5 and 6 DUI causing death to a human. 7 and 8 DUI with damage to property of person of another. 9 and 10, DUI with damage to property or person of another. 11, DUI and serious bodily injury. 12, DUI, serious bodily injury. 13, 14, 15, and 16, reckless driving, damage to person or property, and number 17 is vehicular homicide. I thought there was one death.
There was, Your Honor. The vehicular homicide and the DUI manslaughter are all for one death. However, one count is for the U-Ball, the unlawful balance. The other count is for impairment.
Okay. All right, so at this time, the court does find probable cause.
Your Honor, the state did file a motion for pretrial detention. I gave a copy to counsel. Has Your Honor had a chance to review it?
I have.
Your Honor, I'd ask that based on Florida Rule of Criminal Procedure 3.132, that the court make a finding that the motion is facially sufficient. As the court has already determined probable cause, I would ask that the court hold the defendant no bond on the DUI manslaughter and vehicular homicide counts, and that this will require the state to have a hearing before Judge Fine, who is the assigned division judge, within the next 5 days, where the state will have to present evidence and testimony, and for Judge Fine to make a full finding of whether the defendant shall continue to remain no bond.
Okay. Counselor, did you want to say something?
Judge, I've had a chance to look over the motion. The vehicular homicide charge is a second-degree felony. It is a charge that the court can assess a bond to right at this moment. It does not require any type of hold. I will make a note, Judge, that it looks like even though there's a link about 17 charges, most of them seem to be lessers of the bigger charges. I would like the court to take that into account when you make your consideration for bond. But at this point, I believe the court is able to make a finding today and issue a bond. There's no reason to delay, post any type of hold, or come back for another hearing. Judge, Mr. Wilk has lived in South Florida his entire life. He's a part owner of a business. The day of this incident, which was March 26th, the following day, he went down to the police station because they asked him to do so. When he received a phone call from the detective on Monday, he went down voluntarily to the police station without any incident. He's lived in Broward County consistently since the time of the incident, which has now been 5 months. He hasn't left, and he's basically a U.S. citizen, resided here his entire life.
All right, at this time, I have read the motion. I do find that the motion is facially sufficient. Did you, well, I guess after I've made the finding, the defendant will be held no bond, and the state must set a hearing within 5 days for his division judge to determine.
So, Your Honor, it would be on, the no bond would then be on counts 5, 6, and 17.
Yes.
The court does have to set a bond on the DUI SBI counts, which are 2, 11, and 12. I would just ask the court to set bond at this point at $1,000 without prejudice to the state and the defense to, the state to seek an increase should Judge Fine deny the motion for pretrial detention, and/or the defense to seek a decrease should Judge Fine deny the motion for pretrial detention.
All right, I'll grant that at this time.
And Your Honor, I will be in contact with Judge Fine's JA and CC counsel
Please.
today as soon as I get back to my office so we can get a hearing within the next 5 days.
Okay, thank you.
Your Honor, North Broward has a request.
Yes,
On page 14 of the court's docket, Lester Harrison.
all right. Well, in the meantime, the Spanish interpreter is here, so please let me know who needs a Spanish interpreter as well.
Let me just double check. Ms. Lisboa on page 3, Judge.
All right. Do you swear or affirm to interpret from Spanish to English and English to Spanish?
I do, Your Honor. For the record, Igor Feliciani.
Good morning, sir.
Good morning, Your Honor.
All right, on page 3, let's address Mariel Lisboa Castillo. And ma'am, you are before the court for a trespassing charge.
Señor, usted se encuentra frente a la corte por un cargo de invasión de una estructura desocupada.
and the court does find probable cause.
La corte halla causa probable.
Do we know
Judge,
what,
in speaking of Ms. Lisboa Castillo, the only thing I wish to request is a property order so she can self-bond.
Hablando con la señora Castillo, su señoría, estamos pidiendo una orden de acceso a la propiedad para que ella misma pueda pagar su fianza.
all right, I'll sign that order, and she has a $25 bond.
Yo firmaré esa orden y la señora tiene una fianza de $25.
All right. Does anyone else needs a Spanish interpreter?
¿Alguien más necesita los servicios de intérprete español?
At the other facilities, do we need the Spanish interpreter?
Oh, Brown's good, John.
All right, thank you.
Have a good day, Your Honor.
You too. All right, and then Lester Harrison.
Thank you, Your Honor. Good morning.
Good morning. All right, Mr. Harrison is before the court for a trespassing charge, and the court does find probable cause. Do we know what Mr. Harrison wants to do? Mr. Harrison, what do you want to do today, sir?
I just want to get out of these handcuffs to begin with.
Well, that doesn't answer my question. What do you want to do with the case?
I just want to get out of jail.
Does Mr. Harrison have any prior state?
Yes, Judge, there was a trespass from last year. I'm just checking the case to see if it went through any special divisions, Your Honor.
That was my thought.
All right, let's leave the bond at $25, and if there's anything that we need to do further, you can let me know.
Yes, Judge, I'd like
Alright.
the court to sign an order transferring this case to Judge Lerner Wren.
Okay, I'll sign that order. Thank you.
I'll let her, Jane.
All right.
Yeah,
I'll let her,
thanks.
Jane.
Naisha Brunson? Oh, I'm sorry?
I think that Eric's going to do it.
Yeah,
We need an order, yeah, but I'll
No.
let her know.
yeah. Yeah, I'll sign the transfer. Okay. All right, Miss Brunson, is this Miss Brunson? Okay.
Yes, Judge.
Miss Brunson, you're before the court for aggravated battery with a deadly weapon. And the court does find probable cause. I'll hear from the parties.
One moment, Judge. Okay. Your Honor, the state is seeking a $15,000 bond and an order of no victim contact. It's based on this is based on the allegation that Ms. Brunson stabbed the victim in the back. He had to be hospitalized as a result of his injuries from the stabbing. Your Honor, I would note Ms. Brunson was arrested for domestic violence battery against a different alleged victim in 2017. That was dropped. 2014, prostitution. 2013, she was convicted of felony battery due to prior convictions. She was sentenced to 180 days county jail. 2013, battery on a law enforcement officer. She violated probation. 2012, possession of cocaine. Nothing further, Judge.
Judge, we were going to be asking for a $5,000 bond, and the reason being right now, that's basically all she thinks maybe her mother can afford. Now, she's been here her whole entire life. She's 27 years old. She was working. Unfortunately, she just lost her job. She was working at a hotel in the housekeeping department where she was just making minimum wage, and now she's looking for work. Now, she does understand, and I did advise her, that the court's going to order no contact. She'll be living separate and apart from the alleged victim. She'll be residing with her mother, who lives here locally in Hollywood. My understanding, and Ms. Brunson advised me that her mother is working, and she's also a housekeeper, and her funds are very limited. And that's why we were going to be requesting a $5,000 bond on Ms. Brunson's behalf, Judge.
All right, Ms. Brunson, I am ordering a no victim contact orders. Ma'am, that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, ma'am?
Yeah.
And I'm also imposing a $10,000 bond at this time, okay? Mr. Shea? On page 12, Troy Powers.
Conti, Your Honor.
Okay.
He was sent to courtroom 5870 this morning.
All right.
I'll be up there, Judge.
Okay, Mr. Powers is in court. And then on page 14, Justin Mack. Page 14, Justin Mack. All right, Mr. Mack, you are before the court on two misdemeanor cases. Both are municipal ordinance violations.
Yes.
One was issued on July 25th and the other one on August 1st. Sir, what do you wish to do today?
Resolve them, Judge.
All right, please raise your right hand, Mr. Mack. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And do you understand the offer that has been extended to you? It is adjudication and time served.
Okay.
And
Yes.
do you need any more time to speak with an attorney?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served on both counts.
Okay.
All right, Nathaniel McBride on page 15.
He's a medical reset, Your Honor.
Thank you. Mr. McBride is a medical reset. And Kayla Britt on page 3.
She's approaching, Judge. Hear me?
And Ms. Britt, you are before the court on a misdemeanor KPS. This is on a possession of paraphernalia. This KPS was issued on June 13th because you did not appear for your arraignment. Ma'am, what do you want to do today? Your attorney on this case is on the screen right there, Mr. Shade. Okay?
Judge,
All right.
it's a time served offer from the city of Fort Lauderdale.
Ms. Bridges, just to let you know that the city of Fort Lauderdale's offer to resolve your case is adjudication and time served. Do you wish to accept that?
Can you see number 2?
I guess.
Being held on something else.
All right, well,
Court.
I guess doesn't work.
I guess
Yes or no?
does not work.
First thing goes.
Yeah. I mean, I cannot get I can get a bondsman, right?
Well, you have a bond that the judge set when you didn't appear, and that's $250, and so
All right, I'll do time, sir.
I can leave the bond in place for you to post your bond, or you can resolve the case with adjudication and time served.
I'll do time, sir.
All right, please raise your right hand. Do you swear or affirm to tell the truth? You have to speak.
Yes.
Okay, you can put your hand down. And Ms. Britt, do you understand the offer that has been extended to you?
Yeah.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yeah.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, ma'am, that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yeah.
What plea do you wish to enter, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Okay?
Thank you, Judge.
You're welcome, Mr. Shade. All right, Fania Azor. All right, Ms. Azor, you're before the court. Charge 1 is grand theft, and number 2 is battery causing bodily harm. It's domestic. The court does find probable cause. All right. Does anyone wish to be heard as to bond?
Your Honor, I'm showing.
All right, at all the facilities, there's a lot of feedback, so if we're not dealing with your facility at this time, please turn the mic off.
Thank you, Judge.
Thank you.
Your Honor, I'm showing in 2018 an arrest in Palm Beach County for aggravated battery with a deadly weapon that was dropped. I'm showing, let's see if this is still open. Your Honor, she actually has a pending misdemeanor domestic violence battery in Broward. It's a summons issued case, and it does not appear that she's been issued the summons yet. Hopefully, we can get that served on her while she's still in custody.
I don't have anything pending.
And that, Your Honor, that's why I brought up it's a summons issued. She probably wouldn't be aware that there's a case
Okay.
filed. Your Honor, based on that and the allegations in this case, the state will be requesting a $2,500 bond on count 2, no victim contact.
Well,
Judge, I don't believe Ms. Azor is going to be able to make a monetary bond. I can call her mother, but Ms. Azor indicated to me her mother does not have a lot of financial resources available. Ms. Azor has been living in Florida for quite some time. Unfortunately, she has a disability that prevents her from working, so she's not able to save up any money. She has been staying at the same location for the last 2 years, which is where this incident took place, but she can stay with her mother, and I have the mother's phone number. I would ask the court to consider pretrial release, pending perhaps victim verification, or pending residence verification to make sure she can live with her mother, and whatever other conditions the court would deem to be appropriate.
Your Honor, you can disregard the pending summons issued battery.
Okay. All right, I'll release Ms. Azor to pretrial supervision at level 2 with the GPS. Okay?
what is level 2 with the GPS?
You're gonna have an ankle monitor, ma'am.
All right.
No, it's one case.
Sheila,
So my mom's house is where in Palm Beach.
Sheila Martin.
All right, y'all.
Paul Ryan.
Yes. So count 2 is the only thing that's holding her? Driving while license suspended? Ma'am, there's another capias for a driving while license suspended. This is also a capias from July 14th of 2016. So you resolved the other case yesterday, and now you have this matter. So,
Yes, ma'am.
Mr. Reedy, do you represent Ms. Martin?
Yes, Judge. She's been living here over 20 years. She's had a job working in television. I believe she has a prior suspended license charge in addition to the two currently before the court. My concern is that if she resolves this one, she could end up being an habitual traffic offender. Maybe the state can help us verify if that is in fact the case, because she wasn't really sure when her other conviction was.
The one yesterday is a 2017 case. This is a 2016.
Sorry, hold on one second. Oops. See, that's the weird thing. If you look at the state construction sheet, sorry, I apologize, Your Honor. Your Honor, if she wants to resolve the matter, is that what she's seeking
But
an offer?
is this gonna be her third?
Let me see.
She resolved one yesterday. Let me do this. Let's release Ms. Martin to pretrial supervision on this charge, and then she can meet with her attorney to determine what she needs to do. So, ma'am, the deputy is going to hand you the information for the pretrial office. Ma'am, you need to report to the pretrial office within 24 hours of your release. If you don't report, a warrant will be issued for your arrest, okay? Yep. All right.
All right, good luck, Miss Martin. Straighten out that license.
All right. Michelle Wilson.
Medical reset, Your Honor.
Ms. Wilson is a medical reset. Ashley Breedlove. Thank you. All right, Ms. Breedlove, you're before the court today. It's at charge. Charge number 3 is now burglary of an unoccupied dwelling unarmed. Number 4 is a felony violation of probation with a no bond hold. I find probable cause. You will see your division judge tomorrow. And are the other charges burglaries as well?
No, Your Honor, it's another violation of probation for the same cocaine case. And apparently on that same case, she was, in addition to probation, she was also on pretrial. She violated her pretrial, so she was, there was a warrant for that as well. Your Honor, based on the no bond hold and the allegations in this case, the state would be requesting a $5,000 bond, no victim contact, no return.
Impose a $2,500 bond on charge number 3. Okay? All right, Mavis Johnson. Ms. Johnson is in court. All right, Dalal Abu Jaber.
Medical reset, Your Honor.
All right, she's a medical reset. Marissa McCoy.
She's here, present, Judge, at me, approaching.
All right, Ms. McCoy, you are before the court this morning. Charge 1 is fraud, attempting to use ID of another person without consent. Charges 2 and 3 are grand theft. And I find probable cause, and I'll hear
Judge, our
from.
only request to see is if her bond's been posted.
McCoy. It's not showing.
It will be, Judge. I just wanted to see if it already went through.
All right, the court finds probable cause and the bonds will remain in place. Jennifer Flaherty.
Medical?
Ms. Flaherty is a medical reset. Ileana Munoz.
North Broward, I believe, Judge?
Scum? 1 second, Judge.
Okay. All right, Ms. Munoz, you're before the court. Charges 1 and 2 are misdemeanor capuses. You did not show up for arraignment back on October of 2018. And so a capias was issued. And also, you misscored your arraignment on July 17th of this year. Okay? There is also a felony capias with a no bond hold, which is not for magistrate. And you also have a violation of your pretrial. There's a warrant that's been issued with a no bond hold. So you have 2 no bond holds, and the misdemeanor capuses have $500 bonds attached to them. And you will see your division judge tomorrow at 8:30 a.m., okay?
Yes.
All right, Jada Gray?
And then?
Yes, ma'am. All right, Ms. Gray, you are before the court for grand theft auto. And
Yes.
the court does find probable cause.
I'd ask you to leave the bond in place, Judge. She's going to be able to bond out.
Does she have any? Okay.
She
so-
does. She has prior theft, so I wasn't gonna ask for any type of
All
bond
right, so your
increase.
bond is $1,000, ma'am. All right, Ashley Lavelle.
North Broward.
All right, Ms. Lavelle, you are before the court. Charge 1 is burglary, unoccupied dwelling unarmed, and number 2 is grand theft. I find probable cause for those charges. I guess Ms. Lavelle's co-defendant was before me yesterday.
Yes, ma'am. You said a $5,000 bond.
Does Ms. Lavelle have any prior criminal
moment.
history?
Michelle, do you have any notes by any chance? Did you grab it? Well, could you print out another booking sheet for me, please? Could you print out another booking sheet for me, please, when you have a chance? As far as Broward, Your Honor, I'm showing resisting without violence in 2017, prostitution 2012, possession of oxycodone, alprazolam 2010. I don't know if pretrial has anything from outside of Broward.
Okay. All right, then I'll leave the $5,000 bond, $5,000 bond on count one, and number two has $1,000, okay?
Patient for the last 6 months.
They gave me burglary on the house I'm living in, and the landlord knows I'm living there, so I
Well,
got burglary on the house.
we're not here to get into the facts of your case today, Ms. Lavelle, as I indicated to you earlier. You'll have an opportunity to address those issues down the road. Unfortunately, her phone is at home, and she doesn't know any phone numbers to enable me to contact anyone on her behalf, Judge. So I don't think I'm going to be able to reach anyone to bond her out. So I would be asking for pretrial release.
I believe this was the same argument her co-defendant had yesterday.
Yes, ma'am.
I don't know.
Once I get out, I can have somebody call you guys. Like, once I get out, I can get my phone.
All right, so I'm gonna leave the bond in place, okay? All right, Joseph Labella.
Yes,
All right, Mr. Labella, you are before the court today because you have an out-of-state felony hold. This is out of the state of Texas, and so you should be going before the extradition court next week, okay?
Okay.
All right, Jason Konowski. All right, Mr. Konowski, you're before the court this morning. Charge one is driving while license suspended, third or subsequent offense. Number two is attaching a registration license plate not assigned. Number three is possession of a firearm. In violation of a final domestic violation injunction. And number four is carrying a concealed firearm. So I find probable cause as to those charges.
Yes, ma'am.
All right, and does anyone wish to be heard as to release conditions?
Yes, ma'am. Your Honor, I'm very concerned for the safety of the community based on these allegations, based on the statements that Mr. Konoski allegedly made to coworkers. Even though he's before the court on for possession of the firearm on the day of his arrest, according to his coworkers, Mr. Konoski violates the injunction by bringing a firearm to work on a daily basis. I am requesting bonds in the amount of $100,000 on count three, $15,000 on count four, pretrial release with a GPS monitor level 1, and obviously no possession of any firearms or weapons or ammunition until further order of the court.
Mr. Konoski's been living here in the South Florida area for the last 11 years. He's been staying in the same location for the last 5. He cannot post a monetary bond. I don't believe he has an extensive criminal history. He was a firefighter in Philadelphia, was it?
Pennsylvania,
Pennsylvania?
sir. Lycoming County.
He was a firefighter in Pennsylvania for 12 years. He's a combat veteran of the U.S. military. He was in the Army from 2006 to 2013. He was deployed to Afghanistan during that period of time and received an honorable discharge from the military. I can try and reach out to his sister, and he has a friend whose number he's given to me, who was a member of the Davie Police Department, who also served with Mr. Konoski in Afghanistan. Unfortunately, at this point in time, it does not appear as though he's going to be able to post a monetary bond. And I'm not saying I don't share some of the state's concerns, but these are things he allegedly said. There's been no testimony taken that he actually did say these things, and I don't know if there's a record of it or just going to be the words of these witnesses. So I would ask the court to consider pretrial release for Mr. Konowski.
All right. And State, did you say that he had prior criminal history?
So reckless driving from 2017 out of Palm Beach County. I did confirm the permanent injunction, which orders that he may not be in possession of a firearm. But as stated, so no criminal history really to speak of. The concern is really based solely on the allegations.
All right. There is cause for a concern for not only, the community, but for Mr. Konowski. I'm not sure what's going on here. So at this time, I am going to impose a $50,000 bond on count 3. And $1,000 on count 4. But should Mr. Konowski post his bond, he will be on a level 2 pretrial supervision with an ankle monitor. And no return, sir, to this location, and no possession of any weapons or firearms. Do you understand that, sir?
Yeah, yes, ma'am, I do. I'm also requesting that my case be moved to Veterans Court if possible.
Your attorney will take care of that, okay?
Yes, ma'am. There's no other way to, I do have some medical conditions that I do get treatment through the VA for.
Okay.
I've found it very difficult to get help here in this facility as far as to those conditions. And I was also attacked in this facility upon entrance during in-processing. I really do not feel safe here. As pre-mentioned, they were allegations.
All right, Mr. Konowski, your attorney will have to take the necessary steps to get your case into the Veterans Court. That cannot be done here today, so that's why I'm saying that your attorneys have to take those steps, okay? All right.
Yes,
sir.
ma'am.
All right, sir, good luck.
Thank you.
All right, Mr. Romero? If someone can tell me where Mr. Christopher Dagan is, he's on page 26. When he's in the room, can you let me know?
He's here, Judge.
All right, okay, so we can address
He's
him.
approaching, Judge. Come on up, sir. And Judge, he declined the services of public defender. He advises he's gonna hire his own private attorney, Judge.
All right. Someone signed
I
in.
believe there are some people here on his behalf, Judge.
All right, I don't know if you folks want to say anything, but let me just start from the top. Mr. Dagan, you're before the court. Charge 1 is battery on a person 65 years or older, and number 2 is criminal mischief, okay? I find probable cause for those 2 charges. And State, does Mr. Dagan have any criminal history? And sir, while the state is looking, good morning. You, I'm talking to you. What's your name?
Steven.
Steven?
Yeah.
Okay, is there something you wanted to say?
Yeah. So, a whole misunderstanding at the house.
Well, don't tell me about the case,
Alright.
because today's not the hearing date, okay? So are you going to be posting his bond? And how much bond are you able to afford? Is Mr. Dagan working? Mr. Dagan, are you working?
No.
Okay, and
School right now.
he's in school and lives with whom? I'm sorry, I can't hear you. You have to speak in the
He
microphone.
goes back and forth to his mom and dad.
How are you
We're
related to
separate.
him?
I'm his brother-in-law.
Oh, okay, all right. All right, State?
Yes, Your Honor. He does not appear to have any priors. Based on the facts of the case, the state will be requesting a $5,000 bond and no victim contact on count one and for count two if the bond can stay in place.
I'm sorry, I heard the $5,000 bond after that.
Yes, for count two, just the $500 bond that's already been in place.
Okay. All right.
Your Honor,
Yes.
is there any way we can get the bond lowered, any lower than that? This is first time anything's ever happened, you know? Like I said, it was just a misunderstanding.
All right. All right, as to count one, I am going to impose a $2,500 bond. He has $500 on count two, and no victim contact until further order of the court. He cannot have any contact with, I believe that's his father,
Grandfather.
his grandfather, okay, and that means no phone calls, no text messages, no social media, no third-party contact, which means that neither you nor his mother can relay any message to his grandfather on his behalf, because he's to have no third-party contact. Do you understand that? Okay, all right. All right, good luck, folks. Rico Garcon,
Straight from, no problem, John.
okay. All right, Mr. Garcon, you're before the court. This is an ad charge for false imprisonment.
He's supposed to be, he's scheduled for arraignment this morning.
I saw that at 9 o'clock. So,
And he has private counsel also.
can they, well, he's up at North
That's the
Broward.
problem.
He's at North Broward, he can't even get to his, okay. Do we know who his attorney is?
John Catron.
Okay.
Oh, yeah, great. Yeah, I know. Hey, what time is it now? 10 o'clock right now.
Mr. Linder, do you have his number there?
I do, Judge. It is.
All right, Mr. Garcon, I'm gonna try and call your attorney and see if he's in the courthouse, okay?
All right.
Good morning. This is Judge Jackie Powell. I'm calling from First Appearance Court.
Hi, good morning.
How are you?
I'm okay. How are you?
I am well. Listen, do you know if Mr. John Catron is in the courthouse today?
He's not. On which case?
Rico Garcon?
Okay. Let me get a hold, because Attorney Andrew Parks is on that as well. I believe he's over there.
Okay. Let me just tell you what the situation is. My notes indicate that he should be before his division judge for arraignment, but he's not there. He's still now at the North Broward facility, and he's before me for an ad charge in first appearance. So I don't know if they want to come here, because obviously he's not going to get to his arraignment this morning.
Okay. I'll contact Attorney Parks and have him come to your courtroom.
Okay, thank you.
You're welcome. And what's the courtroom number?
It's 4155 in the West Wing.
Thank you very much.
You're welcome. Take care.
Okay, bye-bye.
All right, sir, we'll recall your case, okay?
All right, thank you.
All right. Jaquez Dillard.
Conti, Your Honor.
All right, Mr. Dillard, you're before the court this morning for some ad charges. So 21 through 29 petty theft. Those are all the charges, petty theft, and I find probable cause. And, I guess Mr. Dillard is in custody on,
He's got an out-of-state no bond hold.
okay. So I will leave the bonds in place on, those charges, okay? All right, Christoph Figueroa
Mr.
Sanchez.
Figueroa, come on up. Judge, Mr. Figueroa declined the service of public defender. He said he was gonna hire his own attorney.
Starting to miss a lot. I'll let you know.
Well, this is ad charge number 5. Mr. Figueroa, are you, do you already have private counsel?
Yes, ma'am.
Who's that?
Excuse me?
Do you have a private attorney?
Yes, ma'am.
Who is that attorney?
I won't wear his name, to be honest.
Okay. All right, so you're before the court today. This is an ad charge number 5
Your
for
Honor,
petty theft?
Yes. From what I can tell, he has a pending felony case. He's represented by the public defender.
Okay. Sir, you are represented by the public defender's office on your grand theft charge.
Is this an ad charge
Wait.
or?
This is an ad
I'm
charge.
sorry, one moment, Your Honor. Sorry.
Judge,
Yeah, it looks like it.
has me to ask the court. He wants to know what the petty theft charge is in reference to.
This is an incident from July 10th at Home Depot, located at 5801 South University Drive. He took merchandise to the total value of $429. Graco box paint sprayer. Okay, all right, I am going to leave the $100 bond in place at this time on this charge, okay? Daniel Marico.
The worst.
He's approaching, Judge.
Mr. Marico is before the court for obstruction of highway. When was Mr. Marico last before the court?
His last arrest was July 18th. He pled the case out. It was a trespass, basically at this location. He received a jail sentence and was released July 24th.
And he wishes to resolve this case, Judge.
Well, did he resolve that case here at first appearance?
Let me see.
He's advised me, yes, Judge.
He did, at a second look, he accepted the state's initial offer from his first appearance, which was 7 days county jail. There was credit for 6 days at the time of his plea.
Well, we're just talking a matter of days. I'm not going to do a time served offer, so he can post his bond, or it's going to be 10 days in the Broward County Jail. That's my offer.
At this time, Mr. Marico advised me he does not wish to accept that offer, Judge.
All right, and, okay. William Lane,
Mr. Lane, come on up, please. He's here at main, Judge.
Mr. Lane is before the court for a traffic KPS matter. And it's for driving while license suspended. Mr. Lane did not show up for a hearing on July 29th. So the KPS was issued for that. Because of that, he has $1,000 bond and, I'm gonna leave it at that unless somebody wishes to.
He advised me, he thought he resolved it. I don't know if,
Was time served on that?
I'll check.
I don't know if Mr. Lender can check. If not, he does wish to try and resolve this case, Judge.
Does he have an idea when he thinks he resolved it?
He told me he believes it was in June. He told me it was here at first appearance court.
What are you looking for? Oh, did I throw them to the other side? On this case? All right, so let's release Mr. Lane. Has already resolved the matter.
Your Honor,
Let's,
can we please make sure the clerk's office then
delete,
deletes the KPS and updates the cases being resolved?
all
Because
right.
in Odyssey, it's still showing it's pending.
Okay. Now I had an open container.
Okay. What date was this case resolved?
It was resolved June 10th.
June 10th. Thank you very much.
This man just,
Yes. So let's ROR Mr. Lane, and the clerk has the information that the KPS will be deleted, this case was resolved. And just so we make sure. We're talking about the case number ending in 486, DC 40A? Okay, all right. So case resolved on June 10th. All right, good luck, sir. Marquise Jordan.
Mr. Jordan is here present, Judge.
All right, Mr. Jordan is before the court for trespassing on occupied structure or conveyance. And the court does find probable cause.
Judge, he advised me that his mom was supposed to post his bond.
I just want to know.
If not, Judge, I was going to ask you, he advised me also he has a clean record. He's 21 years old, been here his whole life. If his bond hasn't been posted, we'd be requesting a straight ROR, Judge.
Does Mr. Jordan have any history? It has been posted? Has not been posted, okay.
yeah. I'm not showing anything, and I don't have an objection to an ROR. Actually, I'm showing he's got an open possession of cannabis, but I still don't have an objection to ROR. I would just ask the court order, he just can't go back to this property. Just don't go back there.
All right, Mr. Jordan, based on the, this probable cause affidavit before me, it says that you had prior noticed about going to this property, Milano property. And so I'm going to order you no return to that location. That's not where you live, right?
No, it's
Okay.
on the front.
Okay, so no return, and you'll be ROR'd at this time. You need to make sure that you stay in touch with your attorney so that you know when you have to come back to court.
All right. He
Okay.
did sign up with the public defender's judge. Thank
Okay,
you.
all right. John Montague,
No problem.
Our judge?
Mr. Montague would like to resolve this matter if we could.
Mr. Montague, you're before the court on a traffic KPS. You did not show up for court last December. And so the KPS was issued on a suspended driver's license charge. He wants to resolve the case?
Yes, Your Honor.
What, is there an offer from Mr. Montague?
Yes, Judge, the documented offer from the state is a withholding court cost.
All right, sir, you wish to accept that offer?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And Mr. Montague, do you understand the offer that has been extended to you?
Not really.
Well, withhold adjudication means it'll be on your record as a no conviction and you have to pay the court costs.
Okay, that's
All right?
fair. Yes,
Okay.
ma'am.
All right, and so do you need any more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves a withhold adjudication and court costs. Good luck.
Thank you.
Tarad Ashley? Tarad
I've been advised bonded, Judge?
Bonded, okay. John Hippolyte?
Mr. Hippolyte, come on up, please. He's approaching, Judge.
All right, sir, you're before the court. These are additional charges. It's KPSs 4, 5, 6, and 7 are traffic KPSs. And these charges are for driving while license suspended, 2 cases. So you will see your division judge, it says tomorrow at 8:30. I am going to leave those bonds in place. Number 7 has a no bond hold, is that correct?
Yeah, it looks like, one moment, Judge. No, it should be 1,000 according to the KPS.
You have what?
Wait, I'm sorry.
Oh, these are no-shows for
It should-
non-jury
But
trials.
count for, according to the KPS, should be $1,000. Sheila, can you confirm?
No, 7 is what I'm talking about.
Yeah, I'm just looking at the KPS. It has each charge as 1,000. I don't know why it got booked as no bond, but the KPS itself lists. Yeah.
So the number 7 is $1,000 bond as well. But I'm not going to make any changes to those today. It looks like these are all for not showing up for jury trial, for non-jury trial.
My understanding, Judge, and I know he's going to court tomorrow, but my understanding is he's been in custody. He was sentenced in a different county, and that's why he didn't show up to court.
Is that correct?
I show a no bond hold
He's
on
got-
counts 1 through 3.
Exactly. I believe that's on a violation of pretrials.
Okay, all right, so we'll leave the $1,000
Is it for the
bond.
same case number?
On
No, it's felony.
7 is, on 7, there's a $1,000 bond, and the other standard bonds will remain in place, and he sees his judge tomorrow, okay? All right, Dwight Winston,
Conti, Your Honor.
all right, Mr. Winston is before the court for, this is also an ad charge, robbery with a weapon. All right, the court does find probable cause.
Your Honor, it's a PBL, but I noticed the court set his other bonds on his other felony charges at $7,500 each.
Okay,
Just gonna ask that you set the bond at $7,500, no victim contact.
all right. All right, so Mr. Winston, you have a $7,500 bond on this charge as well, and no victim contact still remains, okay?
Yep.
All right. Joseph Fermoil,
Refuse? That's a refusal for North Broward?
he refused,
Yes.
okay.
He has a lot of no bond holds.
Mr. Reedy, you,
There's a lot of no bond
all right,
holds.
so these are now at charges 32 through 37. 32 burglary, unoccupied structure unarmed, 33 petty theft, 34 criminal mischief, and then 36, 35 through 37 are no bond holds with violation of probation. So I am going to find probable cause in absentia, and how much bond does he have other burglaries? This is, let's set $1,000 bond on 32, and then the other standard bonds are in place, okay? And he has court tomorrow, so we'll see what happens tomorrow. Jovan Robbins? Is this Mr. Robbins?
Yes.
All right, Mr. Robbins, you're before the court also on an ad charge for grand theft of a firearm.
Judge, Mr. Robbins has a total of $26,000 in bond on counts 1 and 2. I'd ask the court to leave the bond in place on count 3.
All right, I find probable cause, and I believe your bond is $1,000, okay? All right, Joseph Crowback.
Conti.
Morning.
Good morning, sir. This is you're before the court for an ad charge as well. This is now charge number 2. It is felony battery with a prior conviction.
I don't understand about the prior conviction. I don't think I've ever been arrested for anything as far as a battery is concerned, other than what I'm dealing with right now.
Okay?
Your Honor.
Yes.
Okay. First off, he's being held no bond, count 1 for burglary with assault or battery against the same alleged victim.
Okay.
Reading off the information for count 2, it states that he does have a prior conviction for battery in Broward County, case number 93-16092, MM10A, convicted on October 12th, 1993.
It's an old prior conviction, but it's from 1993. All right, you have arraignment tomorrow. I find probable cause, and your bond on this number 2 is $1,000. But you see your division judge tomorrow for arraignment, okay?
Okay.
All right, Sheldon Mason.
Conti again, Your Honor.
All right, Mr. Mason, you are also before the court for additional charges. Number 15, burglary, unoccupied dwelling unarmed. 16 and 17 are felony violation of probation with no bond holds. I find probable cause, and you have court tomorrow before your division judge.
Oh, Mrs. Weeks.
Yes.
I got court tomorrow or the 28th?
I'm sorry, you are correct, on the 28th.
Okay.
I'm used to it being the next day. So tomorrow, the 28th, on the 28th, you have court.
Yeah.
All right, and,
Judge?
yes.
On count 11, you found, you gave a $10,000 bond for the same charge of burglary of a dwelling. That we would request the same $10,000 bond on count 15.
Okay. All right.
It's actually not the same.
All right,
other one was occupied.
You may not,
This one occupied.
was the other one occupied?
Yes.
Yes, Your Honor.
All right, this one says unoccupied, so I'll impose a $5,000 bond, okay? All right. Okay, you'll see your judge. Sage Donati.
Mr. Donati is here, Judge at Maine. He has private counsel, Mr. Michael Weinstein.
Okay.
I spoke to Mr. Weinstein. He'll be here in just a minute.
All right, sir, we'll have to recall it when your attorney gets here, okay? Douglas Slug.
North Broward, Judge.
Okay.
I'm sorry, who did you call, Your Honor?
Slug, Slugg, last name, first name Douglas.
Oh, so he refused to attend.
All right, well, it's a violation of parole and he has a no bond hold. So I find probable cause and he has to go before the parole board, okay? Thank you. John Bullard.
Your Honor, in looking at the docket, he has 3 not for magistrate and a VOP felony. Felony VOP.
Are we talking about Mr. Bullard?
Yes, ma'am.
Did he refuse? Is he not here?
No, I didn't bring him because
Oh,
he has the 3 not for magistrate and a felony VOP.
all right. Well, he has court tomorrow, so I will, he'll see his division judge tomorrow, okay?
Okay, thank you.
Thank you. Xavier Jack.
He's here, present, Judge at Maine, approaching. Come on up, sir.
All right, Mr. Jack is before the court. Charge 1 is possession of forged bank bill or check. Number 2 and 3 are traffic capuses. Number 4 is grand theft. And the court finds probable cause.
Judge, at this time, nothing from the defense. I'm going to contact his friends and family and post his bond.
Okay. All right, we'll leave the standard bonds in place, okay? All right, Stephen Covington.
Mr. Covington is here, present, Judge at Maine. Come on up, sir.
All right, Mr. Covington, you're before the court. Charge 1 is burglary, occupied dwelling unarmed. Across county lines, the court finds probable cause.
Your Honor, based on the facts of this case, the defendant entered the residence without permission and got into bed with the victim, and then fled the scene. The state will be requesting a $25,000 bond with a pretrial GPS monitor on release. And just so the court knows, there was a 2017 battery and aggravated assault charges that were declined. It was a different alleged victim, however, it was still an arrest.
Okay?
Judge, as you heard, Mr. Covington has a clean record. He's been here his whole entire life. He's 27 years old. My understanding of this incident happened earlier this year. It was at his girlfriend's house in Miramar. Right now, he is currently living there. That's where he advised me he's living. He's paying about $350. He lives there with his girlfriend. It's actually the girlfriend's aunt's residence. My understanding is she's the one that's going to be helping post his monetary bond. She works at Wendy's, and she's doing or in the process of doing a waiver of prosecution. Now, Mr. Covington does work. He does odd jobs. He landscaping, painting, and he makes approximately, told me last week he made $150 for the week. So, Judge, I'm asking at this time, because of his strong ties to community, his lack of any criminal convictions, I'm asking for a $1,500 bond on Mr. Covington's behalf, Judge.
All right, yes, good.
Just, for one moment, Your Honor, just to let you know, because according to additional reports, the victim did provide a tape statement. She was in so much fear the evening this happened that she didn't even feel comfortable staying at home. She left the home to stay with a friend that night.
And these allegations, this incident is from May 29th of this year. And at that time, the allegations are that Mr. Covington is our ex-boyfriend since January. And I'm a little bit confused as to if he lives there, why he's entering and leaving the residence through a window.
And I'm sorry, I think the court should also be aware, according to the additional reports, the victim advised that Mr. Covington was calling her cell phone numerous times, advising her, if I can't have you, no one will. He called her via FaceTime, said he was in the area and could see the police at her residence. While the detective was investigating the matter and speaking to the victim, he called her multiple times on her cell phone.
All right, I am going to grant the $25,000 bond with a level 2 pretrial income monitor, okay? No victim contact, no return to that location.
Your Honor?
Yes.
Nothing on this. If it pleases the court, we can recall Rico Garcon.
Page 11, Judge. Good morning.
Good morning.
Yeah.
All right, can we call Rico Garcon?
I think he's at Norris.
Again, then, Judge, that's page 11.
Okay, I have it.
I figured you did.
All right, Mr. Gurkhan is before the court on, this is an ad charge for false imprisonment.
Your Honor, if it pleases the court, Mr. Parks and I discussed the matter. I believe we're in agreement, if it's acceptable to the court, of a $5,000 bond. The top count, the battery, there's a $10,000 bond. He's being held no bond on another matter. I don't believe the court even needs to issue a new no contact order because there was already one issued originally. Actually,
That's correct, Judge.
yeah, you know what, Your Honor, one moment. I just want to make sure this wasn't originally just a misdemeanor, you know?
He's got it all, Judge.
In abundance of caution, I just asked if you just issue the no contact, just if it was already.
Judge, that's okay.
All right, so I'll impose a $5,000 bond on this charge and no victim contact, okay?
Okay.
All right,
All right. You well, Judge? It's a pleasure. Thanks for your
same
patience.
here. All right, Eduardo Bermudez Vargas.
He's here, present, Judge. I may approach him. Come on up, sir.
Did you already?
All right, Mr. Vargas is before the court on a burglary, unoccupied conveyance, unarmed. And I do find probable cause.
Your Honor, at this time, based on the facts of this case and the fact that the defendant allegedly almost tried to get into or actually got into the vehicle of the neighbor, and the neighbor has cell phone video footage of the same day, and he also tried to get into the alleged victim, in this case's vehicle, the state will be requesting a $15,000 bond and a GPS monitor on release, just so that the court is aware. He has a 2015 aggravated fleeing and eluding. And although the neighbor decided that they did not want to proceed with the prosecution in this case, it was a back-to-back incident, Your Honor.
And Judge, just to advise the court, this is Bermudez Vargas. Mr. Bermudez Vargas has also been to state prison on the fleeing and eluding that you were advised of. He was sentenced to 3 years, 8 months. He was released December 1st, 2018, out of Osceola County in 07, aggravated battery with a deadly weapon, robbery with a firearm or deadly weapon, aggravated assault, aggravated battery. He was sentenced to 9 years in state prison. 2005, out of Osceola County, burglary of a structure and grand theft, 1.5 years state prison.
Judge, he's been air charged. He'll be on his second. Yeah, I did see that there's a 72-hour parole hold after magistrate, so it's already been placed. So he's coming back this afternoon? Is there, all right. All right, so at this time, I find probable cause as to this burglary and I'll impose a $10,000 bond. No return to this location, but apparently you'll be back this afternoon for the parole violation hold, okay? Levy Moss,
Mr. Moss is here, Judge, and he declined to serve as a public defender.
all right, Mr. Moss, you are before the court because you have two misdemeanor capuses for not showing up, one at a violation of probation hearing, March 12th of this year, and also for not showing up at a status conference on May 24th of this year. You also have an out-of-county felony hold, which is a no bond hold, and that's for the Orange County. So at this time, I find probable cause. I am leaving the bonds in place. You see your division judge tomorrow at 10:30. Okay?
Okay, can I ask you a question, Your Honor?
Okay.
For the violation case, can I say can you tell me about it?
What do you mean? Which violation? You
Like
mean
the
out of Orange County?
No, not out of Orange County, the other one.
I already told you, you have two misdemeanor capuses, and I told you that you failed to appear for your violation of probation hearing, and you also failed to appear at a status hearing, March 12th, and also on May 24th. Okay?
All right.
All right, Jeffrey Cook,
Mr. Cook, come on up, please. He's approaching, Judge.
all right, Mr. Cook, you're before the court for hiring a vehicle with intent to defraud. Number 2 is violation of probation, and number 3 is also violation of probation. Those 2 and 3 are no bond holds. I find probable cause, and your bond on count 1 is $1,000, and you go to court for your VOPs tomorrow at 8:30, okay? Gautama McLean,
He's approaching, Judge, here, Maine.
all right, Mr. McLean is before the court. Charge 1 is loitering or prowling. Number 2 is felony violation of probation, which has a no bond hold. I find probable cause, and Mr. McLean, you see your felony division judge tomorrow at 8:30, okay? And your bond is $25 on count 1. Christopher Wilberg Palayo,
No problem, John.
all right, Mr. Palayo, you are before the court. 1 and 2 are a violation of pretrial on a felony matter. Those are no bond holds and not for magistrate. Number 3 is a misdemeanor capias. It does have a bond of $50, and the court finds probable cause, and looks like you have calendar call on August 16th before your division judge, okay?
Yes.
Okay. Mackinson Francois,
Mr. Francois, come on up, please. He's approaching, Judge.
okay? All right, Mr. Francois, you're before the court this morning. Charge 1 is robbery, no firearm or weapon. Number 2 and 3 are felony violation of probation, no bond holds. And you have court August 9th, tomorrow before your division judge. And I find probable cause as to number 1. And does anyone wish to be heard as to bond?
Judge, the only thing in reference to count 1, he just wanted to know when the date of offense is. I told him he's gonna be seeing his judge tomorrow to try and talk about a violation.
July 24th
Thank you,
of
Judge.
this year.
The only thing we request, Your Honor, is no victim contact.
All right, so I'll order no victim contact at this time. And you have a $50,000 bond on count 1. Pedro Garcia.
North Broward.
Mr. Garcia, you are before the court for possession of MDMA is number one, and number two is possession of cannabis 20 grams or less. All right, the court does find probable cause. Does Mr. Garcia have priors?
1 second, Judge.
Okay.
He has a 2012 trespass prior, Your Honor.
Okay.
Judge, I have some concerns about Mr. Garcia, Your Honor. I'd ask the court leave the bonds in place.
All right. So we find probable cause and the bond is $1,000. Okay. Travis Manners,
Excuse me, miss, I don't know what that means.
you have $1,000 bond, sir, and
How
your
can I get out, man?
attorney will speak with you further. Okay. Travis Manners is where?
At Maine.
Okay. Thank you. All right, Mr. Manners, you are before the court. Charge one is driving while license suspended. Third or subsequent offense. 2 and 3 are traffic capuses. And number 4 is an out-of-county misdemeanor a hold on a misdemeanor case. This is for Palm Beach County. And that hold is a no bond hold for Palm Beach. The court finds probable cause and leave the bonds in place, okay? Gary Reed,
Mr. Reed is here at Maine, Judge, approaching.
Good morning, Your Honor.
good morning, Mr. Reed. You are before the court, sir. Charge 1 is grand theft. Number 2 is unauthorized possession of blank check. No, forged driver's license. So the court finds probable cause. Does Mr. Reed have prior criminal history?
Yes, Your Honor. He has a 1995 robbery and a 2016 grand theft and an utter forged instrument.
Okay.
Judge, Mr. Reed, the $2,000, he's not gonna be able to afford a post. He's basically indigent. He did advise me that he's applying right now for disability. He's been here living in our community for 30 years. He advised me no one can help post his bond. He's asking to be released on pretrial release.
Right, I am going to release Mr. Reed to pretrial supervision, but he'll be on an ankle monitor. Okay? RR to level 2 pretrial.
Thank you, Judge.
Cedric Blevins.
Come on up, sir. He's approaching, Judge.
Mr. Blevins' bond has been posted? Okay.
That's what I was gonna ask.
So, Mr. Blevins, you have grand theft and a grand theft auto. I find probable cause, and as you heard, your bond has been posted. Lamar Anderson
Mr. Anderson is
is
North
going
Broward.
to be reset. All right. Just make sure it's not, Mr. Anderson has been reset to the PM docket, okay? Oldie Silvestri.
Sylvester, come on up, please. He's approaching, Judge.
All right, Mr. Silvestri is before the court. Charge 1 is grand theft auto. Number 2 is resisting officer without violence. I find probable cause.
Judge, we're gonna ask if to see if his bond's been posted. Hopefully it shows already.
It's not showing that his bond has been posted yet.
Okay, well, he advised me that his family went this morning, so it's probably waiting on the bondsman to come over here.
Okay, all right, he has $1,000 bond. And Brandon Barther,
Mr. Barther is approaching Judge here at Maine.
Mr. Barther, you are before the court. Charge 1 is petty theft, and number 2 is dealing in stolen property.
Yes, ma'am.
The court does find probable cause. Does Mr. Barther have priors?
Yes, Judge, he has a 2017 Grand Theft Auto.
Nothing to add from the defense, Judge.
All right, so he has a $3,500 bond on 2. Okay. Juan Gutierrez,
Mr. Gutierrez is approaching, Judge. He's here at Maine.
Mr. Gutierrez is before the court on charge 1 is burglary, unoccupied dwelling, unarmed. I find probable cause.
Judge, I'm going to be requesting anywhere in the neighborhood of $1,500 to $2,000 bond on Mr. Gutierrez's behalf. My understanding, Mr. Gutierrez has a clean record. He's 19 years old. He attended J.P. Taravella High School. He lives in Tamarack with both his father and his brother. His father is working. He is a mechanic. They've been residing at that location for 1 year. He believes the rent is about $1,000. I'm going to be contacting him after court to let him know what is going on with his son. Having said that, Judge, he is working. He works for a company called Sparkling Image. It's a car wash in Sunrise. He's been there for about 5 months, making $8.75 an hour. My understanding, Judge, is when he was picked up with law enforcement, he cooperated with law enforcement. My understanding, Judge, is I believe the date of incident happened sometime last year. But because of his strong ties to community, his lack of criminal record, I'm going to be asking for anywhere from a $1,500 to $2,000 bond, so hopefully his father can afford that.
Your Honor, and pretrial's looking up. All right, that being said, my concern is obviously the allegation that he broke into a home, but also what his actual identity is. There's numerous instances which indicate, and documented here, that he has an alias of Juan Diego Buenambre. As you can see on his short arrest form, that's the name that was put in first, and it lists that he has an alias. Your Honor, I would also direct the court's attention. I don't know if you have a copy of a David printout, face sheet.
I do.
As you can see, it has the name Juan Diego Buenambre. It does appear to be the same person, Your Honor. And I would direct the court's attention to the probable cause affidavit. When law enforcement contacted him, he acknowledged his name was Juan, but would not verify his last name. And then I also see here in the warrant system, going back to July 31st, Broward Sheriff's Office, when they were putting the warrant in teletype, received information from Coral Springs Police Department that his real name, in fact, is Juan Diego Buenambre.
I do see that.
Judge, my understanding, he was picked up at his home, so obviously law enforcement knew where he resided, went there, spoke to him. They took him down to the police station, and that's when my understanding is he cooperated with law enforcement.
All right. I am going to put Mr. Gutierrez on pretrial supervision. He is going to be on an ankle monitor. Okay.
Yes, Judge.
Says for an order of no return.
And no return to this location, no victim contact.
Thank you, Judge. Pretrial's gonna come and contact you and you give him all the information as far as where you're living, okay? You're fine.
Chihad Moran West.
He's here present, Judge Jermaine.
All right, Mr. West, you're before the court for selling methamphetamines, that's charge 1 and 2. And I find probable cause.
Judge, Mr. Warren West gave me the phone number of his grandmother who I intend on calling after court so she can post his monetary bond.
All right, so he has $2,500 on each count. John Sinius.
Mr. Sinius, come on up, please. He's here present, Judge.
All right, Mr. Sinius, you're before the court. Charge 1 is driving while license suspended, third or subsequent offense. Number 2, expired driver's license over 6 months. And number 3 is not for magistrate, but operating a vehicle with unsafe equipment. I do find probable cause.
Judge, I'm going to be contacting Mr. Sinius' wife to post his monetary bond.
All right, so the standard bonds are in place.
Good luck, sir. I'll call after I get out of here.
Okay, Robert, Scott Ferris, Scott Robert Ferris.
Hello, Judge. Again.
Hi, Mr. Ferris. I think we have everything right today. Even though, it's not in order, but they're all there, so.
Can't get too greedy.
I try. Number 1, Mr. Ferris is aggravated battery with a deadly weapon. Did you go to court yesterday? Or,
Yes, ma'am.
okay, so you already know what the charges are. You were arraigned on them?
They just, I'm not sure if I got arraigned on them or not, but I know
Did
they
you
just
say-
filed me for September.
Oh, okay, so
he was
you
a-
entered a not guilty plea?
Yes, ma'am.
So you were
Yes.
arraigned, okay?
Yes, Judge Duffy handled the arraignment because Judge Merrigan is out this week.
Oh, okay, all right. So charge 1 is aggravated battery. Number 3 is carjacking with firearm or weapon. Number 4 is robbery with a firearm. Number 5, attempted burglary. Number 6 is aggravated assault with a deadly weapon without intent to kill. Number 7 is criminal mischief. And number 8, touch or strike battery, okay? All right, so did we already have bonds on all these charges, or some of them?
Not all of them, there are some add charges. I'll start with the 2 PBLs, Your Honor.
Yes,
They are changing charges from burglary with assault or battery. The court set $15,000 bonds on those originally. They
that's
have
3
been-
and 4 on our,
Yes, ma'am.
okay?
I have provided the court with a supplemental report, which goes into more detail, Your Honor. All I can say is I would ask, based on this supplemental report that the court did not have access to at the first appearance, I would be seeking a finding of proof evident or presumption great. No victim, and no bond.
No,
Your Hon-
who represents Mr. Ferris?
I believe the public defender.
Oh, okay.
Your Honor, he was witnessed by the victims, by multiple witnesses that are familiar with Mr. Ferris through previous contact at the business. I would note There are allegations, one moment. The other charges. On the aggravated battery, Your Honor, there was a bond set of 10,000. I don't believe there was, and he actually wasn't mentioned in the initial report. I would note the victim, Mr. Kern. I think it's significant noting that the injuries he suffered were considered to be life-threatening at the time, that he had to be taken to the operating room at North Broward Hospital due to suffering severe head trauma from the attack from Mr. Ferris. I'm going to be requesting a $25,000 bond on count one. On the attempted burglary of conveyance, well, there's a $1,000 bond, that's fine. The aggravated assault of deadly weapon, Your Honor, I'm going to be requesting a $10,000 bond. I'm also going to be requesting a pretrial release with a GPS monitor and no victim contact.
Having reviewed the probable cause affidavit, we would object to the court making a finding of proof evident presumption grade at this point in time. It's the highest standard of proof that we have. And I've also reviewed the affidavit the state provided to me earlier today. The state's called no witnesses, introduced no evidence. I would submit to the court that that is not enough to make a finding of probable cause based on these reports. And I ask the court to set bond for Mr. Ferris. If the court feels over our objection that proof evident presumption grade is the appropriate finding, then I would ask the court to exercise its discretion and set bond for Mr. Ferris.
All right. Okay, I reviewed the original report, the supplemental report, all the interviews conducted by law enforcement. And so at this time, I am going to make a preliminary finding of proof evident presumption grade as to charges 3 and 4, and Mr. Ferris will be held no bond on those charges. And on count 1, I'll impose a $10,000 bond. On count.
Ma'am, can I ask?
And
Can I
count
ask you a question?
6, hold on just a moment, I am going to impose a $10,000 bond. No victim contact. And just so, Mr. Ferris, you know that the no bond hold is a preliminary finding. It is without prejudice. You can have your bond hearing before your division judge, okay?
Yes, ma'am. I was just, I had to get a surgery done. That's what, I was kind of pressed for a little bit of time. I'm not saying that.
All right, well, since you've been arraigned and since you have a division judge, your attorney can file a motion so that your judge can hear that and you can present whatever evidence you have in regards to your surgery and such, okay?
Yes, ma'am. Thank you very much.
Okay. All right, Brandon Walker.
He's approaching, Judge, you're me.
Mr. Walker is not here yet.
He's coming.
All right, Mr. Walker, you are before the court. Charge 1 is possession of controlled substance without prescription. 2, 3, and 4 are felony violation of probation. Those 2, 3, and 4 have no bond holds. I find probable cause. It looks like he was supposed to be in court today. So that hearing will have to be reset, and you have a bond of $1,000 on one, okay? Cayenne Johnson,
Conti, Your Honor.
all right.
Good morning, Your Honor.
Good morning, Mr. Johnson. All right, you are here because there's been a change of charge from grand theft to possession of a weapon or ammo by a convicted felon. How much bond did Mr. Johnson have before?
Your Honor, on count one, you issued a $50,000 bond, as well as a GPS monitor on pretrial release.
Your Honor, it was,
It's a,
originally, it was a $10,000 bond,
Mm-hmm.
but it was a grand theft, so it looks like it was changed to an unrelated offense.
it was,
Yeah, he has a no bond hold out of county for grand theft auto as well.
okay?
Whatever bond the court deems appropriate, we're fine.
All right.
May I ask something, Your Honor?
Yes, sir.
Well, I just wanted to advise that I know that I currently have pretrial release, which I'm fine with, which is I'm totally fine with. And I was just wondering if, because my family is having a hard time with coming up with the bond as it is pretty high. I was wondering if at the court's discretion, if I do get, if I am given a bond, it could be like a little lower, so my family could be able to make the bond. I mean, I do work from home, and so I have no problem being with pretrial, as that's where I'll be content with being at the house. But they're asking for, well, the bondsman is asking for a collateral when we only rent, so I don't have like that type of money, and it's kind of hard.
Well, here's the thing, you have to go before your division judge on one, because today, the only thing that's before me is this new number two, which is a possession of weapon or ammo by a convicted felon, and also you have a hold from Dade County.
Right, I've already spoken with my attorney in Dade County. It's just the AC hold, as the judge wanted me just in that my body to appear in the courtroom, and I already have like an affidavit to remain on bond with that. I just spoke with the attorney the day I spoke with her and my family. Spoke to them the day before yesterday. So they were saying they just wanted me in the courtroom. And
Yeah, but what I'm saying is besides your Dade County thing, there's another charge that's not before me today, so,
Your Honor,
yes.
just to give the court an idea.
Yes.
This case has been transferred to career criminal court before Judge Bailey's.
Okay. All right, so I'm gonna impose a $5,000 bond on this one that's before me today, okay?
Yes, ma'am.
All right. What was is he on GPS on the other charge? Huh?
Yes.
Okay, so we'll leave that in place with the GPS, okay? Jason Cook?
How you doing, ma'am, Judge?
All right, I'm doing well, Mr. Cook. You are before the court today, you have two charges. These are change of charges, okay? So, yes?
The bonds were originally set at $5,000 each, and he also has no bond holds.
Okay, so just so you know, there's from burglary, unoccupied structure, unarmed.
And Your Honor, I'm sorry, just to let the court know, I believe Judge Feld, I believe she handled the first appearance. She found for conveyance and wrote it in on the.
Okay, so, it's just here today for perfection of the paperwork that, probable cause was found for burglary, unoccupied conveyance, unarmed, okay? And how much bond did Judge Feld, set? $5,000 on each charge? All right. So that remains the same, sir, and it looks like you have arraignment on August 12th, okay?
Yes, ma'am.
All right. Charles Hebert.
Judge, he's approaching, and he declined the service of the public defender. He's gonna hire his own attorney.
All right, Mr. Hebert, you are before the court. Charge one is DUI, alcohol or drugs. Number 2 is driving while license suspended. Number 3 is refusing to submit to a DUI test. Number 4, failure to register motor vehicle. Number 5, attaching registration license plate not assigned. Number 6 and 7 are traffic infractions, failure to provide insurance, and failure to display vehicle registration. I find probable cause as to all those charges. And does Mr. Hebert have, well, this is a second DUI. When was does he have anything else?
Yes, Your Honor, he has a 2015 DUI and as well as a 2012 reckless driving. There's a pending obviously in 2019 DWLS, habitual offender, and a possession of cannabis, possession of drug paraphernalia as well.
Okay. What was the date of the previous DUI, I'm sorry?
I'll look that up, Judge.
Okay.
Oh, the date of the previous DUI. It was a 2015.
Okay. All right, so Mr. Hebert, you have a total of $1,750 in bond, 1,000 on count 1 and 750 on 2, okay? All right, Jose Nunez.
Please approach the judge. He's your name. Come on up, Mr. Nunez.
Good morning, Mr. Nunez, you're before the court for grand theft, and I find probable cause.
Judge, Mr. Nunez gave me the number of his brother who I intend to call after court to post his bond.
All right, and you have a $1,000 bond, okay?
Yes, sir.
All right, we were waiting for Mr. Weinstein.
Your Honor?
Yes,
We can, I believe we can proceed if Mr. Donati would approach.
They're gonna tell you.
Sage Donati, yes.
Your Honor, I've been in contact this morning with Mr. Weinstein.
Is that what happened the last time he was here? Was Mr. Weinstein here the last time
Yeah,
you were
yes,
here?
he was.
Oh, okay, okay.
I think we're thinking of another time we called.
Okay.
He has so many cases.
I
today.
know, so.
Your Honor, unfortunately, he is stuck in another courtroom and can't make it. We discussed the matter. We've agreed on the burglary counts. We've agreed to $7,500 bonds on each one, no return. You may recall, I believe Mr. Donati appeared before you last week. He's got a no bond hold on a couple of burglaries with damage over $1,000, a $25,000 bond on a robbery case, multiple other bonds.
All right,
Mr.
so-
Weinstein did advise me that he is aware of Mr. Donati's ad charges, and he will be taking the appropriate steps in front of the assigned judge to address the bond.
All right, sir, did you hear all of that? Okay, somebody please turn his mic on. All right, just so you know that 14 is burglary, unoccupied structure unharmed. 15, criminal mischief. 16, burglary unoccupied. 17, petty theft. 18, criminal mischief. 19, burglary unoccupied. 20, criminal mischief. 21, burglary unoccupied. 22, petty theft. And 23, burglary of a structure, okay? And based on the conversation between your attorney and the state, I am going to impose a $7,500 bond on the burglary charges.
Yes, ma'am.
And then that will cover, and then the other standard bonds will remain in place, okay?
Yes, ma'am.
All right, sir.
Thank you.
Okay. All right, I believe we are at the end of our docket, and I will see everyone this afternoon at 1, okay?
Yes, ma'am.